Thank you, Dr. Singhvi. It's always a pleasure to have you. And as I always say, he's one of my favorite guests because he makes law and politics both simple to people like, I think, people like me, because we are all eminent lawyers in the panel, in the audience also today. Dr. Singhvi, welcome to our panel today. We are also celebrating 75 years of the Constitution. But they've, in Parliament, there have been a lot of debates on a lot of issues where lawyers like you have a vital role to play. For instance, we've had the Places of Worship Act that is really doing the rounds today. We've had the Supreme Court also pass a landmark judgment on it. So what is your take on this?
Thank you, Priya. Normally get paid to speak before judges. This time I have to, the judge has to keep silent and I have to be able to. Thank you for a very generous introduction. Well, it's interesting you talk about the Place of Worship Act because I appeared just yesterday as one of the two lead counsel in that batch, and without encroaching on the sub judice nature of the matter, I think an excellent holding order has been passed by the Supreme Court just yesterday, and we appeared at 3:30, 3:45. It has two parts, which is why it's excellent. It prevents further suits being registered till they hear the whole matter. And they can be filed, but they are non-starters. And for the existing matters, it prevents any effective, the exact words are effective, final or interim orders being passed in the existing suits. Now, why do I say it's important? First and foremost, while the matter is pending, as one of the judges put it yesterday, there cannot be a race between the apex court and the courts subordinate across the length and breadth of India, where suits are being filed. Almost like rabbits. Every day we find a new suit coming up in a different part of the country. The Supreme Court will decide it. The Supreme Court will hold one way or the other. But certainly on the interim, on the balance of convenience, etc., it is indisputable that there must be a quietus, a stability, and no upheavals while the Supreme Court is seized of the matter. That is the basis of this order. It's not any final order. Now, if you ask me the larger question about my own views on the Act, I have no hesitation, and I don't mean to impinge on the Supreme Court. That's only an interim order. We'll be arguing it finally, and I don't know which way it will go. But I have no doubt that a well-considered legislative decision was taken way back to draw a line. Nobody's saying that the line is right. All lines are arbitrary. And I approach it from a different viewpoint. I have no doubt that any number of monuments and buildings and places of worship in India lie on top of diverse religious structures. I am a Jain, you are a Buddhist. There are many Jain and Buddhist structures over which other structures stand. And so also Hindu structures. The question is very simple: how far will you go? Where will you stop? At the Qutub Minar? At the Taj Mahal? You already invoked Ajmer Sharif. So, as Gandhiji said, an eye for an eye will do nothing but make everybody in this room blind. So you need to draw a line. The Act has drawn a line for us. And I don't think there is any value in opening it. Last point. Unfortunately, the courts below, till yesterday, and I'm glad the Supreme Court is crystal clear now, has had a very weird nuance in my understanding. The nuance is that you are prohibited from going to dinner by a law of Parliament. Parliament says, I cannot go to dinner in this ballroom. But yet you are entitled to examine which kind of dress I must wear for dinner. That is apparently the basis of the Supreme Court not acting earlier and not stopping these suits, something which the court rightly did yesterday. So the argument was that, look, while the structures can't be changed, why can't you have surveys to find out the nature of the structure? If the end result is predetermined by an Act of Parliament, now more than 30 years old, then what's the point, at least till you finally decide the validity of the Act, to keep on inquiring that while we can't touch the structure of the Act, let's find out the nature by surveys. It's exactly like my dinner analogy, although it might sound facetious.
But the petitioners are also questioning the validity of the 91 Act, which brings us to my next question. What are the pillars of the basic principles of Constitution? Where does judicial review begin and end?
Well, the pillars of the Constitution is a large question. We can have a whole program or a whole afternoon on that.
Give us a short answer, if a lawyer can...
Short answer is difficult, but there are several fundamental pillars of our Constitution. They are institutional and non-institutional. The pillars I would identify, there can be many more, is of course secularism is one pillar. And secularism not in the sense in which we politically use it all the time, but in the sense of India being the world's, planet Earth's most diverse spot, where it's a sense of self-preservation when we want to impart a sense of belonging to every Indian. As Bhargav said, of the people means each person gets a feeling of co-ownership of democracy. So you have to give that feeling. Another pillar is fraternity, a word hardly remembered. It is much more than the negative word tolerance. It is a word which is supposed to encourage actual cherishing of diverse viewpoints. A third word is federalism. These are all pillars. And it's exciting how India has become a very federal country, although our framers thought of it as a unitary country. And that's a different story altogether. And then there are other institutional pillars like Parliament, like the Election Commission, the CAG. These are all pillars which have stood the test of time, which make us different from every other country in our neighborhood. Indeed, I always say that roughly 30 to 40 countries became independent from the yoke of imperialism in the 1930s and 40s. And ask yourself this remarkable question: why is India the only one out of those which came out from Dutch imperialism, British imperialism, French imperialism, etc., which has remained a democracy? It's because of these pillars. And you see the wrecks and ruins of constitutionalism littering the landscape in all around our neighbors. So we have to cherish these pillars.
But in operational reality, it doesn't always work like that.
Absolutely. Absolutely. And that's a much larger issue. We are going to debate it on Monday. And I will be one of the speakers on Monday, so I don't want to anticipate my own address in Parliament. But the operational reality, there's a hiatus between the theory of the pillars, the text of the Constitution, the context of the Constitution, and the spirit in which we are operating. The Constitution does not contemplate the operational reality of the meaning of inclusiveness and plurality, which we are seeing for some years now. The Constitution does not contemplate the sense of fear or divisiveness, which we are also seeing. The trust deficiency, the distrust quotient. The Constitution does not contemplate the new definitions of federalism we have. We can use fancy words in lectures: cooperative federalism, competitive federalism. What is the reality? I'm giving only examples. I have done, never before in 75 years, but I've done in the last 2 years, at least 4 governors' cases from 4 diverse states of India, where a bill is sent to a governor, and the governor in 9 out of 10 bills simply doesn't decide. Because you know that if you send it back and it is referred again back to you, then you have no discretion. So you decide not to decide. Then you have to go to court to get a direction to the governor to decide. And in 3 of those cases, when we have gone to court and got that direction, the governor passes one or approves one bill out of 9 or 2 bills and then refers the rest to the president. What suffers? Governance. This is happening in the south, it is happening in eastern states, it is happening in northern states, all parts of India. I am myself a counsel in those. Take for example CBI use. Right or wrong, the CBI can't enter your home without your consent. Now today you have weird examples where they said something happened on railway land. Railway is a central subject, so CBI can go there, even though the entire thing is happening in state X. These are examples of abuse of federalism, different from the pillar of federalism which constitutional law like Bomai taught us. And I can multiply the examples. The Election Commission has acquitted itself well in maybe 80% cases. But in the 20% where push comes to shove, their record is very poor. I happen to be the person who's dealt with those 20% cases, and their record is one-sided. Same could apply to so many institutions. Parliament today, when have you in 75 years seen a disruption of, a expulsion or rather mass suspension of Parliament of 142 persons? I mean, short of somebody murdering someone or slapping someone in Parliament, never has any conduct been so egregious as to justify 142 suspensions en masse. Well, you might as well have a unilateral ex parte parliamentary democracy where you don't need the opposition then. So these are many examples you can multiply.
Which brings us to another debate that is doing the round, and actually this is the right forum for it also. We hear a lot about the basic structure. What is the basic structure? Can you just help us out in explaining the history and the origin of the basic structure?
I must advise you to have separate programs for each of the questions you're asking. But basic structure is a fantastic doctrine. Let me assure everybody who's interested and not interested. And I am sometimes shamed by seeing pygmies talking about, in denegatory terms, something which is the pride of India and the envy of the world. The basic structure will remain the ultimate bulwark, according to me, between dictatorship for any length of time in this country and democracy. The basic structure, in one sentence, why I call it fantastic, no other country thought of it, no other judiciary thought of it, says that a constitutional amendment passed by 2/3 of Parliament, etc., can itself be unconstitutional. A constitutional amendment can be unconstitutional is an amazing doctrine. And I don't have the time to discuss with you, but how it developed, how it picked up the philosophical roots from a German called Conrad, who gave a lecture in BHU, who talked of the essential features, and how that lecture found its way to a Madras professor, who then gave it to Nambiar, the father of our current last AG, Venugopal. And by that time, Golaknath, he tried to use it, Nambiar, and it didn't succeed. Along came Keshwananda Bharati. Nambiar was not so well, so he said, go to Palkiwala. And he passed on the draft which he had made. And Palkiwala, with his brilliance, developed it into a fantastic doctrine. And ultimately, in that 6-6 versus that 13th judge, 13th was lucky for India. Justice Khanna ultimately said, A, that the basic structure means some parts, the essential parts of the constitution are unamendable. And more importantly, what is unamendable or not will be decided on a case-to-case basis by the judiciary. So there's no point lamenting that this is an unelected body, these judges aren't elected. They have the last word, and ultimately you have left it to them thinking that absolute power corrupts, and the executive dictatorship, which sometimes can happen in the Westminster model, will not be allowed to be happen in case you start tinkering with the basic structure. Otherwise, as Conrad said, and I in fact in a lecture in Rajesh Jindal, traced it back to a 1920 set of 2 articles, one by a Frenchman, one by a German, Schmidt and Heroux, who said philosophically that ultimately it means that if a law is passed saying that all blue-eyed babies alone shall have the right to vote, well then law is passed by 2/3 is valid. What's the problem with it? Basic structure says no. So it's a fantastic doctrine.
Are you surprised that people in Parliament are questioning it? Because it says the power of the Parliament is not absolute. So obviously the Parliament is going to be questioning.
Well, the power of Parliament was never intended to be absolute. Forget basic structure. Much before
basic structure was never in the Constitution also.
No, much before basic structure, these judges were reviewing parliamentary legislation for decades. So how can you say parliamentary power is supreme? The supreme power till Keshwananda Bharati was the Constitution. So you tested laws passed by Parliament against the higher anvil of the Constitution, and you struck down innumerable laws. The only difference between basic structure and judicial review is that this is a superior power of judicial review, which says that even a constitutional amendment can be unconstitutional. But the judges have been wise and sparing. They don't use it indiscriminately like a wild, unruly horse. They've actually struck down constitutional amendments, very few and far between, on basic structure. And I think this power, any constitutional functionary or private state actor or private actor who denigrates this doctrine, I think needs to relearn his constitution.
Can you recall any recent examples where the basic structure has been called into question, or some debates which have made a point?
There have been many examples. I mean, sometimes good, sometimes bad. I don't necessarily agree that the National Judicial Commission bill should have been struck down. Not because I was the lead speaker in that, not that reason, but there is a view that the collegium system in the judiciary has also partially failed. But that what was used is important. The principle used to strike down the National Judicial Commission bill a few years ago by the Supreme Court was independence of judiciary, which is a basic structure. Then there are many more examples today. And I think that residual power of saying that must remain. It must remain.
We've also another recent debate I want your views on is your stand on the EVMs. You know, you were part of the delegation that went and met the Election Commission. Also, Congress has been raising this. Where do you stand on it personally?
First of all, I am speaking personally, not as a spokesperson for any party. My personal stand, and I was just discussing it outside there, is a much more nuanced one. The demand can be for ultimately changing the EVMs and going back to whatever paper ballot. But that demand has to await the fullness and ripeness of time. When it will happen, nobody knows. So I don't think you generate much resonance by saying, in a general sense, EVM hatao, EVM debunk karo. My stand is much more nuanced. I think there are very serious, and I've examined it on data. I've led delegations to the EC, and I have had meetings where data is, I'm talking of hard data. The nuanced reaction should be that a lot of things which actually alter the level playing field of elections need to be looked at by the Election Commission, and they are not sufficiently looked at. Take one example, which we gave to the Election Commission officially about 3 weeks ago. I'm not saying it's right or wrong, but you need to examine raw data. The Election Commission needs to examine it. I'll give you 3 quick examples, there's not enough time. Example 1, in Maharashtra, 118 constituencies, of which 102 were won by the state ruling party, had differences exceeding 25,000 votes on the names of the voter lists, that is 35, 40, more than 25, between the 4-month period between the Lok Sabha and the Rajya Sabha elections. Now that's a massive number of seats and a massive number of difference in that short time. Second example, you have no reason to not progressively increase the VVPAT trail from 5% or so which you have now to a much larger number. Assume I'm wrong. Your job is to evoke confidence in the system. The average person must have much more confidence. So why don't you start dealing with the paper trail in, let's say, each year increase 10% and reach 50%. 5% is not a valid sample size. Number 3, that paper falls straight into a untouchable kind of box. You need some system by which contemporaneously, a day or two later, that paper can be checked. Do it only in maybe 25% cases and then 35% cases, and maybe you could put a cap of 40% cases. Do you know that the total time extra taken to declare the result, if you start doing a physical verification of this kind, is not more than 36 to 48 hours. Now 48 hours addition to a 7-week election cycle is not oont ke muh mein jeera also. It's nothing. So if you are able to give confidence to the electorate by a 48-hour delay in declaring results, but doing a paper trail examination, I don't think it's any great thing to say that, look, it will delay the election results. You've already taken 7 weeks. And there are many more nuances. So my point is, I'm not saying EVM hatao, EVM galat hai. These are the things which the Election Commission, and I am sorry to say, the Election Commission on such queries has not always acquitted itself creditably.
Well, that is a debate I will leave for the Parliament. But another debate, hot topic is this one nation, one election. I mean, I know where your party stands, but again, since you're speaking in an individual capacity.
One nation, one election is a very, very warming, attractive, prima facie, extremely attractive concept, especially to drawing room classes. It's a wonderful sense of uniformity, discipline, organized. सब चीज टाइम पे होती है, एक साथ होती है, सही होती है. In practice, apart from a serious doubt on constitutionality, I don't think it can work. If it works naturally, no doubt. It worked naturally from 1947 to 67 or 66. Now the moment you have a democratic will changing, and you have a hiatus in not 1 but 5 states, you need a law to say that despite the democratic will changing, by whatever, withdrawal of support, defections, whatever, changing fickle loyalties, a law says that you shall continue to the nearest date, which you are now currently suggesting is a midway mark. Now, how constitutional it is to artificially prop up something without the numbers. I agree, you can have a reset button. You can start the whole system once. But subsequently, again, if you have a 1967 and a 1990s situation, to always keep on a mandatory legal reset button means that you have become a minority government, but you shall continue till the next reset button. is unattractive, it's an implausible and an unworkable concept. The main thing nobody answers of the proponents is how it will work. And the report which has come is riddled with such general blanket statements which have lots of infirmities.
Does it impinge on the principles of federalism also?
That's the other aspect. Of course it does. Regional parties today rule more of India than either national parties like Congress or BJP in population terms and in geographical terms. Regional parties rule much more. Now regional parties have different cycles of electoral politics. You are actually affecting that, and federalism will be an issue. These are all constitutional challenges possible. It has a great sense of order and a great sense of good uniformity. But it's actually, if you examine it deep down, it's only appealing to our sense of, orderly conduct. There are a lot of ways in which you can insulate the disruptive cycle of elections, but I don't think one nation, one election, just because you may be a government who wants one language, one dress, one habit, one approach, one religion,
one prime minister.
Can't be one. No, I won't say that. I am nuanced in my response, but you can't have one. The whole thing we celebrate in this country is diversity. I always say it has to be unity in diversity, not uniformity upon diversity. You can't have uniformity upon diversity.
Also, you wear many hats. You're a lawyer, you're an MP, you're also a national spokesperson for the party. I've seen you argue the same thing in 3 different ways. You do it in a press conference, you come and make the same case in court, then you come to the parliament. So are there different ways of communicating?
It may be interesting for you, but it's a great learning process for me. I believe that it's extraordinarily learning. It's not good for health, and I don't do it as much as I used to do in my younger days. But it's extraordinarily interesting learning process, because you'll be surprised if you pick a theoretical topic X. I mean, I'm not saying what the topic is. You can pick a theoretical topic X and make a frame in the morning, 2 hours arguing 3-4 cases on it. The approach, the idiom, the style is cold, logical, pointed, volume X, page Y, and then the judge decides something. If you take the same theme X, and I've done it innumerable times driving from court to parliament, which is 2 kilometers away, and you open a debate, which I've done for years and years, the same theme has a different idiom and a different rhetoric in parliament. The audience is different, how you put it is different, the canvas is wider, the style is different. And then I have done this again on the same day at 4 o'clock. You do a Gagar Mein Sagar, what I call the Nobel Prize for Miniaturization, for the press, a press conference at 4 o'clock. The same theme will have to be encapsulated in a few sentences with or without some spins to sound sufficiently attractive for the press to listen to it. Now these 3 things are similar, but they have totally different approaches, audiences, receptivity, absorption and styles.
So who is the most difficult to convince, your parliamentary colleagues, the media or your lawyers?
You all are difficult to convince. This is not ultimately based on result. It's based on trying to deliver a decent performance. I mean, you'll be surprised how many people come back to us to argue cases after I lose their cases. People are intelligent enough. They know the weakness and the strength of a case. They want their point of view to be put effectively. They know that after that also they are likely to lose. I don't think they blame that person, be it in parliament or in courts, so much.
Speaking of parliament, you also spoke earlier about so many MPs being suspended. How do a lot of people are talking about, especially from the opposition, about the relevance of parliament today. Government is very happy, they're getting their work done. So is the opposition walking into the government trap? Why not go and debate inside the house instead of, disrupting the house?
I don't want to sound political on the narrower issues, but certainly I believe that parliament is the temple of democracy. We don't have democracy, remember. We have parliamentary democracy. We have 2 words, not one. And we tend to think of only one word. It's a parliamentary style of democracy. And if you diminish or dilute parliament, you diminish democracy. Parliament is the grand inquest of the nation. Grand inquest means it's the place to raise issues. It's the place to seek answers. And it's not a place to get results. It's a place where you can just raise everything for the attention. That's why I call the grand inquest. Now you must have violently differing views. This is the heart of Voltaire saying what Parliament represents in a British system. Not so much in the Senate and the reps because there's a different system there. There's a third entity, a veto. But in Parliament, you are supposed to have the principle of Voltaire that I disagree totally with what you are saying, but I will defend to death your right to disagree with me. If you imbibe that, then you have healthy parliamentary democracy. Now, that means you give time. That means you are prepared to hear unpleasant views.
Both sides.
That means both sides, obviously. See, one side will have less difficulty because the numbers are with them. In any system, I may be more numbers or you may be more numbers. But the majority, it is actually a place where you have to show largesse to the minority, to the opposition. And I think once you do it, we've had examples. I mean, the person who liked to abuse was the ultimate Democrat in this respect. He said, give extra time. Do you know, it's very interesting. I just read yesterday, I'm not talking about any current context. When the first impeachment motion was moved against a person like Mavalankar, there's been no impeachment motion in the Rajya Sabha till now, but there has been impeachment motion against the speakers way back in the 60s. Nehru said that this is a frivolous, false one.
Right.
But you must give extra time to the opposition because they've raised such a huge issue. This is on record. I'm not talking about Nehru, I'm giving an example of the spirit of parliamentary democracy. Take Central Hall, for example. The new building you have is fantastic. I mean, it's luxurious. But Central Hall in the old building is something where a Vajpayee would sit there, a Singhvi would sit here, a Rajnath Singh would sit there, a Sharad Pawar would sit there. And the rule in Central Hall is that everything you say is off the record unless you say it's on the record.
Correct.
And the oldies in your field, the journalists know that. And you would have everything free and fair. Now the two ladies in Bangladesh can't sit in their Central Hall. The Nawaz Sharifs and the Ziaul Haqs of Pakistan have no Central Hall. So Central Hall is not a space, it's a concept. That's the heart of parliamentary democracy. Unfortunately, this time by a physical space change, we don't have a Central Hall. I have to walk half a kilometer to sit in the lounge of the Lok Sabha, and they have to walk half a kilometer here. We both have a canteen, luxurious no doubt, but we don't have a Central Hall concept.
Or you can come here and meet everybody.
No, there is a move afoot across parties, not one party, even the ruling party, to approach the Honorable Prime Minister and say that, look, create a Central Hall kind of space for us. Because you have no idea of the spirit of democracy which is there in Central Hall. The freedom, the openness, the lack of fear, the cross-fertilization of ideas with no fear of being misreported.
Okay, my last question is, there is also a move to increase the number of MPs. You think that will create more chaos or have more, structured debate? Will it improve the quality of debate, representation?
No, that's an issue which impinges on something else. That's a issue of population. And the real issue there is not about acrimony or not. The delimitation, if it suggests, as it is likely to, a huge increase in population, then you are devaluing one man, one woman, one vote. By saying that despite an increase in population, this table has the same number of seats. This table is now 10. It got 2 seats earlier when it was only 5. Now it is 10.
Right.
The counter argument is that those states which have controlled population get diminished. So that's a vexed issue. But I think you will have to have a middle path. You'll have to increase Lok Sabha, and possibly the new building is now able to hold 700, 800 people. I mean the new chamber. Our chamber is more or less the same, but their chamber is increased. For that eventuality. Now where you will put a line, I don't know. That will have to be done with some acrimony, and a middle line between those states who have been successful in population control versus those states where population is increased. Because one man, one vote, one woman, one vote is the fundamental heart of a level playing field for elections, and that is the heart of democracy.
Okay. Last question. I wanted to remember, if you can recall the 3 debates that you felt really, made you proud to be in Parliament. It doesn't have to be from your side, but just 3 debates that really,
I have had the privilege of being asked to open from the Treasury benches virtually every major debate from 2006 to 2012-13. One which stood out was the Lokpal debate, because I was chair of the Standing Committee on Law. And in 4 months, we reported on a very, very disruptive, vexed issue, the Lokpal bill. You'll be surprised how vexed it was. And we had everyone except Anna Hazare coming and giving evidence before a committee of which I was the chair. And we had stalwarts on my committee, from the Lalu Prasads to the Paswans. Arun was there for a while, Arun Jaitley, Mr. Jethmalani Senior, so many, every party on that committee. And these people came and gave. Prashant Bhushan came, Arvind Kejriwal came and they gave a report. And I wrote the report personally, opening Parliament's Annex E on 4 or 5 Saturdays and Sundays. And that report has had minimum dissensions. It's a report you must see. But what happened thereafter was all hell broke loose when we went to Parliament. Because inside the committee, real work is done. Cameras are not there, confidentiality is there. So there were hardly 2-3 dissents. But in the House, things broke. But the debate which followed, they asked me to open, which is not normally done for the chairman of a committee which has opined on the subject. But they asked me to open. And we had a wonderful debate. And Arun for the other side opened. As you know, the respondent opens in Parliament, not the petitioner, not the ruling party. And he cited the footnote which I had put in the report about how the Lokpal had travelled a full circle 38 years from the time when Nehru had asked a young member of Parliament in 1962, to which zoo does this animal belong, when my father, as a 30-year-old Lok Sabha member, used the word ombudsman. And then my father invented and coined the words Lokpal and Lokayukt. That's
really?
on record.
Yeah.
So that's how the debate started. And the amount of cross-party support and spirit it generated, it was a very strange coincidence that 5 failed bills of Lokpal finally found fruition 35 years later under a committee of which I was chairman. So that's how sometimes things happen. But there have been other very interesting debates, and I've done a lot of them, which is always memorable. When Parliament functions, you have gems, you have great, great debates. But sometimes it doesn't.
Sometimes it doesn't. So last thing, are you a better politician or a better lawyer?
That's a difficult one. I think I'm bad at both. But law has always been my first love. And I actually genuinely don't like the word politics. So I like to say that I'm a professional who's in public life. So public life is a better word than politics, because politics, which is not a bad word at all at one time, has become very demeaned and diminished. So I enjoy multiple roles. I mean, the third role is that of the media with which I started. As I said, multitasking is the bane of my life. It's also the joy of my life. So I don't know what will happen if I leave the bane of my life or the joy of my life.
Well, last word goes to who. Thank you so much for this conversation.
आपकी आवाज नहीं आ रही.
The beauty of our country is unity in diversities, as you said also. It is unique throughout the world, and we are being respected and we are being appreciated because of these diversities. And if you know that the origin of our Indian subcontinent, it started from the supercontinent connected with Australia and moved to Asian plates, and it's collided. So my point is, in between is traveling, Adivasis came, then Dravidians came, and then your member of parliament said that Aryans came, then Mughals came, then Portuguese came, then Britishers came. These diversities, we should maintain it, and there is a book by Nehru Sahab, Nehru ji, that the discovery of India, a serial was also there. So why this kind of things present government is doing to divert, to divide the country? And our historical fact is that we are beautiful in diversities. Thank you.
The anchor will summarize.
I have another question. It's a legal question. Yeah, Mike, please. It's a legal question. So, Dr. Singhvi, we had, many judgments on the issue that says that judicial review in our constitution is a part of basic structure. Now, you're going to argue Places of Worship Act as a lead constitutional. It's a matter of national importance. So, to my understanding, what I have seen when I was reading this act, that prevents judicial review. So, do you think, basis the judgment that we have on this subject, will this impinge the constitutional validity of Places of Worship Act? Because I see as a lawyer that this appears to be a big legal hurdle.
Okay, the first longish comment with a question hidden in it. The first part I can only say I agree. I mean, I can't say more than I agree with the first part of your question completely. I, of course, have no time to go back and travel back in time as much as you have. But certainly the first part I agree, but it's a larger philosophical question. You know, when we practice fraternity, inclusiveness, pluralism, we actually do no favor to anyone. We are actually acting for self-preservation. A diverse country, India is by far the most diverse spot on planet Earth. When the Americans talk of salad bowl or melting pot, they have no idea what diversity is compared to India. So this is a self-preservatory exercise we do for our own good. We don't do any largesse to anyone, and we are not being specially kind to anyone. So that part is fully agreeable. The second part I've already answered when I talked about the pillars of the Indian Constitution in terms of conception, design and theory, and the operational reality of many of them. It is not enough to have the text of the Constitution, it is not enough to have the context, it is the spirit. And I gave you 7-8 examples of that. So I think both parts of your question stand answered in that sense, without repetition. As far as your other question is concerned, I think the issue is not a question of ouster of judicial review per se, because it has been held for decades now, from the time when emergency happened and those clauses were put in the Constitution that you oust judicial review of this or that those ouster clauses are not final. Ultimately, the court, and especially the Supreme Court, will always have the residual power of doing judicial review, despite a specific clause saying no civil court should look into it. Those clauses only oust civil suits of the kind going on now. And the issue, real issue there is only going to be A, is this act valid? B, is the drawing of the line valid? And C, is it in any other sense, for lack of legislative competence, which is the third ground raised, invalid? I don't think judicial review is an issue in that one, because Constitutional Court's judicial review is admittedly alive and kicking, despite such clauses which are intended to bar only civil courts starting to go behind the act.
Right.
Dr. Singhvi.
Okay.
Of course, that is why it is looking into the validity of the act. That's how it's looking into the validity of the act. It's actively, just yesterday the matter started.
Thank you very much, Dr. Singhvi, for this conversation and to celebrate 75 years of the Constitution. Thank you so much.